Hello, my name is Brian Carlisle. Many of you know me from my channel, but I wanted to first introduce myself a little bit, and then I wanted to give an update on the status of cannabis in Canada, medically and otherwise, for those that are a little on the unsure about the current regulations proposed, the laws, and some of the policies that relate to those laws, and how they'll affect you as a patient, perhaps as a licensed grower, and perhaps even as a physician or as a dispenser. So first I want to give a little background. I've been attending university for quite some time. I've attended several: University of New Brunswick, University of BC. Now I've been attending the University of Fraser Valley for several years. I finished my associate's degree not long ago. I'm just finishing up my Bachelor of Arts degree with double extended minors in criminology, criminal justice, and individual arts. And as part of my studies in the UFE, I've been involved with a certain amount of research and scholarly articles with the university and what is known as the Crime Lab, or the Center for Public Safety and Criminal Justice Research, headed by Dr. Darryl Plecas and his outstanding team of criminologists. First, I'd like to discuss some of the research prior to my involvement here at the university. Like most universities in Canada, the focus was on the criminal sanctions and criminalization of marijuana. And medical marijuana, of course, didn't exist in the original Narcotic Control Act, as we all know. That was through a series of charter challenges, was effectually changed into the Controlled Drugs and Substances Act in about 97 to 98, and subsequent regulations came into force, including at some point later the Section 56 provision was added to the CDSA, and unfortunately no regulations of how that worked. That was basically an exemption provision under the actual federal act, the Controlled Drugs and Substance Act. And basically what that enabled is any person, for medical, scientific, or otherwise in the public interest, can apply to the Minister of Health directly for an exemption for various purposes: testing, personal use, whatever. And that's been enforced, or been in the statutory legislation federally for quite some time. In response to that, and in response to many applications that were sent in, or requests, I guess at that time, a lot of patients and physicians asking for access to this program that didn't exist, but so that their patients couldn't be arrested or charged, even though in their involvement with Canada's, at that time, marijuana black market. And so the government's response, through a further series of charter cases, which really has been the driving force behind the medical marijuana and marijuana advancements whatsoever in the last 20 or 30 years in Canada, the United States, and across the world. It has not been the government's willingness or decisiveness or research or academic perseverance to change that. So, for example, a lot of the main research prior to my involvement with the Center for Research was regarding plants, how plants could create the $1,000 value per plant, and therefore had that criminal sanction of that type of trafficking and possession for the purpose and whatnot, and so enabled and still enables those without a license to be sanctioned quite viciously under the CDSA, even to this day. And luckily, because the medical acts are still in flux, many patients are able to challenge the regular act as being also invalid, and there have been many successful challenges regarding strictly non-medical usage. So the majority of the research here at university was in that area, and sometime in 2008, the center contacted me and asked if they knew of my background in doing my own research with my own federal MMAR license at my own garden, and I had done a few studies, several that have been published in Cannabis Health magazine. Maybe some of you have read them, issue 7, issue 6, and those were mostly just regarding ways to produce higher yield cannabinoid profiles, higher yield dry bud outputs, and higher and yields for secondary extraction sources from non-bud plants. There's other information that has yet to be rendered from that, but those were quite eye-opening experiments that helped me to realize that the issue of plants really was not a main, or even maybe perhaps was not as important a variable as had scientifically been previously thought of here in academia, and of course through the courts and the justice system and law enforcement. So the lab approached me and asked if I'd be willing. They actually, by 2008, Statistics Canada had a few very strange publications regarding decreases in cannabis arrests and decreases in coming to the attention of, but yet no decreases in the usage. And these discrepancies had gone on for, I think, in 07 and 08. And so the lab actually asked if I would put together a research paper on possible reasons why that might be. And so I wrote up, I did some research, and I wrote up a paper basically explaining the commercial marijuana industry and how the black market industry and how it was working. And that paper, it did end up getting turned into a small scholarly article by a couple of professors who cite me as the reference. But it also made the department and the Attorney General's office realize the need for further research that could be peer-reviewed and could be published in journals, and perhaps be added to the advancement of the criminology and the criminology and the persecution of the marijuana industry in Canada. So what we basically did is we looked at the research I had done, and we basically had included that with other research that was available around the world. The National Institute of Drug Abuse has their own research lab in the University of Mississippi and several other organizations. So we basically looked at all different articles. We did an article review, or otherwise there was a content analysis study. Basically formulating from that, we created a calculator to determine the variables that actually are involved with creating different amounts and profile variations in cannabinoid production on a commercial level, of course. And then we further looked at the commercial industry itself and the changes and its current status and where it was growing and its value. And we came up with an actual unitary measure to determine how big it is, where, no matter where it is, from a street to a house to a country, whatever. So that was part of the findings that we were able to glean from our research. That has actually been published in several different articles and subsequently been reviewed by several other scholarly journals. For example, the law reviews in various states, like Washington and Colorado, obviously, and whatnot. So that's unfortunately I actually had the opportunity to learn about that study and some criminology courses that I took here at UFB subsequent to its publication. So I know it is being taught. To what level I don't know, because I still hear of people being arrested for plant counts being one of the main variables. So anyway, so that was the purpose of our research. It opened up the eyes of a lot of the people in the Center for Justice, and luckily it brought about a lot of discussion and debate, not just here but obviously across Canada, and many cases came about, including the Renault case, which of course is the one that decided that the regulations that were enacted by about 2001-2002, called the Medical Marijuana Access Regulations, were in fact still not constitutional for patients, didn't work, didn't provide supply, and in fact only further fueled the black market in Canada. And so basically, the MMAR went under a series of different consultation inputs from patients, myself, I'm sure many others inputted, and asking for a program that would enable a variety of cannabinoid profile strains available in dispensers, but of course covered under our medical services plan, or whatever work plan or disability services plan or whatever, so that it's not an out-of-pocket issue like it currently is. And even though it's out of pocket, it's only out of pocket for $5. You buy from the black market a gram, maybe 10 if it's really, really good, which is rare. And of course, to grow, you can grow for about less than $2 a gram if you're growing your own marijuana. All expenses in, according to our own research here at the university. So the MMPR is basically, which is the new medical marijuana production regs, that is proposed to be basically filtered in starting March of this year, and by March of next year it's supposed to be in full force, and it's supposed to phase out the MMAR at that time, in March of 2014, which obviously is, for a lot of reasons, is worrisome to at least several different groups. But we'll go into that in a bit. First, I would like to look at what the MMPR is going to do, for example, to patients or to the physicians. Well, at the point of currently under the MMAR, physicians can basically sign and fill and basically state that they're not condoning, not consenting, not recommending. They're just the patient is using it, and this is the condition they're saying they use it for. This is why, blah blah blah, and basically it's good for a year. It's based on dosaging of plants, not actual medication amounts or trichome percentages or whatever, strictly on the plant amounts, dry bud. I'm not even sure in dry. And so, of course, it's totally unstandardizable, and has made several statements by the Canadian Medical Association, the College of Physicians, Canadian Medical Protection Association, and nurses and various other medical professionals have also echoed in that they are not looking towards the new changes under the MMPR, which basically will be not just a statement or a signature from these physicians about the need for the patient to use, but in fact a declaration swearing that they require this amount for this duration, this frequency, and maybe even this strain and what it's for and what symptoms. So those sort of informations are still unknown by almost all physicians and professionals. So what it may end up doing is putting it right back to where it was when it was the Section 56, where it just basically was if no other alternative medication was available. So we're hopeful that's not the case, but it looks like from a lot of the information coming out that they may that the changes may not include all the conditions that are currently allowing 50,000 Canadians to have the ability to possess and grow or designate someone else to grow their own marijuana without being charged. Of course, still no real supply. And supply is another main issue, which I'm going to discuss as a problem with the MMPR. Second issue, of course, so physicians, of course, are very hesitant now to swear under their license that a patient must need this amount without some kind of scientific proof or even a dose to review it. Have something to guide, which ones they did a sativa hybrid, what kind of hybrid, and how much and how long, and for what strain, or for what symptom. And I mean, because these are unknown, it could create a real difficulty in physicians signing it for anything other than very chronic illnesses and where they have no other alternative. So, which is worrisome to many patients that have been using it as an alternative medication for many of their conditions, but I don't want to have to go back to using preservative, which they could, which is unfair to enforce, and may in fact create some charter violations in their own way. So another reason is, of course, the courts. Will the courts and law enforcement be able to deal with these constant changes? Of course, there's a new law called the Mandatory Minimum Prosecution Law, which basically was an omnibus bill created to enable for people that are convicted of production or manufacturing marijuana illegally to have mandatory jail sentences given. Some are just ridiculous amounts, useless amounts, more creating further tax burdens on the public, and obviously making no change to the issue, obviously, and may in fact drag in other actual medical patients into doing actual time in jail because there's no proper supply still available. And many of them, unfortunately, aren't able to grow properly, so they grow a large amount of plants to try to finish the garden with maybe their limit, if they survive, which is a very common issue when growing a natural substance like a plant. So these whole plant numbers, again, for patients can never work and should be an irrelevant issue, which is why under the commercial system there will be no plant count issues. The commercial licensee will be able to allow to grow as much as they want to, and to ensure that their supply is available for purchase by whoever. Anyway, lastly, the effect on Canada's black market. Well, without it, unfortunately, the supply that they're asking for the current MMPR licensees, their applicants, to use is a legal supply, which is currently the Plant Prairie Health Canada supply of seeds that they're calling pistillated, which are another nice way of saying hermaphrodites, and basically non-feminine, if any at all, bud making, and basically most likely not possible to make proper marijuana for any company that invests hundreds of thousands or millions of dollars to do this. This goes through all the hoops just to get a supply from the government that will not produce a strain that can grow properly at all, or in the minimum will be purchased by a patient for use. So it's setting up a system for a lot of entrepreneurs that could end up losing everything just for further government mismanagement, which is what this is, just another mismanagement decision without following any of the real input that many of us have continued to put in, whether in writing. I actually drove to Ottawa in 2000 and attended the first stakeholder workshop with Health Canada for the marijuana medical purposes regulations, and myself and 10 other of the only people that were licensed or had applied were there, along with many stakeholders, giving them a lot of this advice, and all of it was just brushed over, and the decision was made to just make regulation with no supply and let the black market run as it will. Hopefully that doesn't mean for the last 12 years or 13 years now that Health Canada has had some kind of unofficial covert involvement with enabling the black market. I'm hoping that's not true, but all the indications, even on their own site, indicates that they support the black market supply system for patients, which to a criminologist seems abhorrent, and would be considered to be not only corrupt, but would be considered a conspiratorial act on a criminal level. Anyway, finally, I wanted to discuss, of course, the MMPR regarding patients. If in fact the MMPR does not enable patients to purchase their own through their medical plan, and the supply that they can use, patients will have no choice but to file charity challenges asking for people to continue to grow for them, if they are able to grow their own, especially those that have invested six figures into their gardens over the last several years, and those that cannot or will not, such as myself. We're not farmers, we're criminologists, and we don't want to be involved with anything to do with making medications of any kind, whether it's marijuana or any medication. I wouldn't even make insulin, I couldn't, but I wouldn't make insulin if that was necessary. It's something that the average a citizen shouldn't have any responsibility in. It's a government issue, it's a provincial issue, and hopefully provincially whoever the next elected government will actually grab the horse by the reins and will create a provincial program to subsidize the federal program so that the provincial licensed patients are able to access a marijuana supply without the black market. And one of the main ways that has been proven by the country of Israel when they legalized medical marijuana is as the country creates its own supply, it researches and grows, it immediately starts to import from another exporting country of medical marijuana, in this case Holland. Holland exports to many different countries. Something like 700,000 kilos have been exported so far for various programs, and has enabled patients to have access to supply covered under their local medical immediately, no delays, no dangers to their health, regardless of the government status. Canada, unlike that, has chosen for over 12 years now to try to get a supply and make patients purchase off of all of the different black markets. Originally it was Hells Angels and Rock Band and the Triads, but now it's all the 440 gangs in the Fraser Valley and everywhere that are basically running Canada's medical marijuana market, whether it's through themselves on the black market covertly or through helping supply the different compassion clubs, who of course have no supply for themselves to offer their patients. So the system basically is completely funding the black market's ability to make countless amounts of money. And in fact, I plan on doing some research into marijuana counterterrorism domestically and internationally, and to see how much involvement it has in some of the acts that have happened even here in North America, and what in fact Health Canada and other countries are involved with to enabling or not, which we need to look into. A couple more issues that I wanted to go over. The current thing in Canada we known as the Nuisances Bylaw, or Drug Enforcement Act, or Control Drugs Enforcement Act bylaw, or every provinciality, every municipality basically is enacted some form of this, unless of course the challenge was successful, which has happened in several BC municipalities now. But basically it enables police to act without warrants, to just come into the house as capacity as some kind of inspectorate and without the right or power, and then of course once they're in the house to then switch their hat back to police officer and to begin a criminal investigation without the right to do that either. So it's been a real big problem, and it continues to be a problem. Abbotsford finally is one of the last municipalities to review it, and not just regarding the bylaw regarding licensed MMAR patients, but regarding the little bylaw regarding to other harm reduction issues, for example, needle exchanges and safe needles and shooting galleries and whatnot, or like Abbotsford, Vancouver has several exemption programs in force that work very well in making sure that there are no intravenous drug using deaths occurring whatsoever in Vancouver now. And unlike that, Abbotsford and Fraser Valley up till now has basically turned a blind eye and enabled youth and adult drug addicts to just die on our streets. And it's an issue that's now finally before the City Council. Myself, I've even spoken on it in 2005 when it was brought up the first time. Here we are in 2013. They're finally discussing and looking at reviewing it. Hopefully it will be amended to enable the four-pillar approach to deal with addiction of the disease, not as some kind of crime, to put the blame game away and actually to take care of this issue, which is obviously a driving force behind the homeless issue, which is another issue that is dear and close to myself, and is hopefully going to be a big election issue this time. Last but not least, I wanted to discuss the recent changes in America regarding outright legalization in the states of Washington and Colorado now, basically creating a taxation system and income generating system identical to their liquor control system that they have, and a very smart way to deal with adult recreational use, not to mention a way to create a tax base that was otherwise not available, and a way to further defund the value and also hopefully take away a funding stream for their black markets. This is a great opportunity for us to follow here in Canada. I think the provincial governments should look at implementing a system like this in every province as a way to bring the value down to almost nothing, so that the black market, medical or otherwise, has no income to be made in marijuana, which, as we know, according to even alcohol prohibition, is proof of that. When there's no value to be made, the black marketeers, or at least 99% of them, switch industries or move on to some other area or whatnot. They're not going to be involved with the marijuana black market if there's no money to be made. So that is the most logical, academic way that we know of anywhere in the world to deal with prohibitionary issues that are creating violence and corruption and crime, especially ones like the marijuana issue prohibition, which is now almost 80 years on now, and multi-billion dollars of wasted time and money and effort that otherwise could have been put towards growing Canada into a vibrant superpower that would need no other assistance from no other country,
no other natural resource other than the hemp resource, not just marijuana, but hemp for fuel, fiber, for making planes, cars. Henry Ford had a patent on vehicles. We can make jet liners. We can make silk stock